Okay, so now we will move on to the commencement of arbitration. We have seen the arbitration agreement. We have seen the appointment of arbitrator. Now let us move on how the arbitration will be commenced. Arbitration proceeding will be commenced. Okay. So before seeing how the arbitration can be commenced, we must know certain requirements. I'm sure all of the friends here, you must be aspiring to become arbitration professionals, which is very ideal for your profile. If it is the case, then there is certain requirements. Okay. I request everyone to listen carefully, which is required to be fulfilled. What are they? Let me open my slides. I hope it is visible.
Yes, sir. Very much.
All right. So, what are the requirements to become an arbitration professional? First, we must know what are the substantive law to be applied to the arbitration. What is a substantive law? That is the law applied to the subject matter of the dispute. We know for the construction contracts, the matter will be contractual disputes. Therefore, the Contract Act should apply. In UAE, it is UAE Civil Code. UAE Civil Code, it is having the provision for the contractual disputes. So we must be aware of. Also, we must know what is the Evidence Act. In UAE, what is the Civil Code pertaining to the evidences, what it says? What is the limitation period for invoking the arbitration? So these are the substantive law. Okay, we must be aware of. We must know what are the provisions of the substantive law relevant to the dispute. Having said that, whether you want to become an arbitration professional or not, that is different. But even if you are a contracts or commercial professional, you must know the layers of the dispute. The first layer is in your contract. Of course, you must agree that most of the contracts, whether it is in UAE or India or elsewhere, they must have very limited grounds of your remedies. Therefore, we must know the next layer of the remedy, which is the law. In your case, in UAE, it is UAE Civil Code. Specific example will be the time bar clauses. In your contract, particularly in FIDIC contracts, the time bar clause will be there. If the notice is not given within 15 days or 28 days, the contractor, he is deemed to waive his right of claim. But if you look at the another layer, the law, the UAE Civil Code, it bars such clauses. Suppose if you have a dispute and if you escalate it to the arbitration, that particular clause will not stand in front of the arbitration tribunal. So therefore, it is essential to know what is your contract and what the law says to the relevant provisions of your contract. If you know that, then you can successfully defend your rights. Also, very often, the price escalation clause that must be struck down by your employer. But such bearing clauses that is not tenable when it comes to arbitration, because your law it allows. So therefore, you must know the application of the substantive law. That is the very first step of becoming a arbitration professional. The second step is you should know what is the procedural law. Procedural law, the name itself, it says what are the procedures applied in the arbitration. The first one is your arbitration law, Arbitration Act. In case of UAE, it is Federal Arbitration Act. In case of free zones such as Dubai International Financial Center or ADGM, they have their respective arbitration acts. Therefore, we must know the important provisions at least, how the arbitrator is appointed, what is the timeline, okay, what is the language allowed. All these provisions you must know, okay, and evidences. What kind of evidences can be provided? You know, what the law says. Evidence Act. You know, in case of India, it is Evidence Act is there. But in UAE, again, the same UAE Civil Code. Civil Code, it is an all-inclusive law. You know, it speaks about everything. It speaks about contracts. It speaks about evidences. Okay, everything pertaining to the civil disputes. Therefore, we must know the provisions related to the evidences. What kind of evidence you can produce in the arbitration? Why it is important? Arbitration is all about adjudication. The two parties, they are coming to the arbitrator. They are presenting their disputes. One, of course, one person, he will present the dispute. Another person, he will defend it. He will say, no, there is no dispute. Whatever the person presented is incorrect. Now, the arbitrator, how he will adjudicate? He will adjudicate based on the submissions in front of him. What is the submission? Evidence. End of the day, he will make his judgment, his arbitration award based on the evidences submitted in front of him. But that evidences, that should be permissible evidence. They cannot submit some state secret as evidence. So therefore, we must know the important provisions of the evidences. In case of electronic evidence, suppose if you are submitting emails as your evidence, you cannot just like that produce it. There must be some certification requirements. You must know. So therefore, you have to go to the respective statutory authority. You must get it stamped, certified. Then it will become an evidence. So such kind of awareness should be there. Okay. Then administration. How the arbitration case is being administered. Okay. That is very, very important part of the arbitration, because it is a very lengthy process, documents oriented. Okay. So therefore, right from the commencement up until the award, rendering of award, there are several procedures involved. So therefore, diligent case administration is very important. We must know. And then very important element is drafting. Arbitration is all about drafting. Okay. 99% it is drafting only. There are several letters, submissions, orders to be produced by the arbitrator, applications he will receive. He must respond to that. And of course, finally, the award. The award should address everything. He should not leave anything, okay, in the air. Otherwise, the award will be set aside by the court. So therefore, in each and everything, whether the arbitrator is writing a letter to the parties or the parties are writing letter to the arbitrator, drafting is essential. It is all about convincing the arbitrator, isn't it? You may have entitlement, but if you don't draft properly, then you may lose your entitlement. The other side, They may be on the wrong side, but they must have presented in a very professional manner by way of diligent drafting. So therefore, arbitration is all about drafting. Okay. So if you want to aspire, if you are an aspiring arbitration professional, the first and foremost step is you must upskill your drafting. Okay. And what is the best way is reading the decisions, judgments related to the arbitration. Then you must be knowing how they are framing the drafting. Okay. The best, my experience is whatever you want to say in 100 pages, the story, you must be able to put it in one paragraph. That should be, that one paragraph should be the beginning of your drafting. So that settles the arbitrator. Okay. The arbitrator, he should be able to digest what is in the 100 pages. That makes the arbitrator comfortable. Then you can set the drafting chronologically. What happened from the beginning, how the agreement was signed, what are the important elements of the project, and what happened, what are the disputes, why the delay happened, who is attributable, what are the expenses incurred, and what sort of remedies you are looking for, whether it is delay damages or price escalation, whatever it is, you must be able to draft it properly. Okay. So these are the certain essential skills you must have before embarking on the arbitration journey. Okay. Now we'll see how the arbitration is commenced. We have already seen notice of arbitration. That is the first step. As I have already mentioned, there may be a few concepts we may be repeating, and the purpose is just to register in your mind. Okay. So notice of arbitration, it must have all these elements, whether it complies with the limitation period. What is the limitation period? If you have a civil dispute or commercial dispute, you must invoke the arbitration within a defined period. If you are sleeping for years and then you are coming back to invoke the arbitration, which is beyond the stipulated time period, then you are waiving your right. That is called a limitation period. It differs from jurisdiction to jurisdiction. In India, you must invoke the arbitration within 3 years from the date of the dispute. Whereas in UAE, it is 12 years in most of the Middle East jurisdiction. So we must be aware of. Also, the notice of arbitration, it should specify outline of the disputes, what is your claim, when it was repudiated, number of arbitrators, and what are the remedies you are seeking. Okay. And we have already seen what are the essential elements to invoke the arbitration. There should be a repudiation, pre-arbitral steps should have been completed, there should be a valid arbitration clause, limitation period should not have been exhausted, arbitrability of the dispute should be arbitrable. Okay. And responding, suppose if you are approached to become an arbitrator, to get an appointment as arbitrator, then you must first do the conflict check. That is what we will do. If somebody comes to us asking us to be an arbitrator, first thing we will do is conflict check. We have seen more than once what are the conflicts. So that should be the first step. Then do you have sufficient time to devote? Okay. And if it is a very complex technical dispute, it is better to say no. And conflict of interest, we have seen there are 4 types of conflicts. Conflict with the dispute, conflict with the counsels. Counsel means advocates. Conflict with the parties, conflict with the outcome of the case. Okay, so arbitrator, he should declare that he doesn't have any conflict. He is having the necessary experience. He possesses time availability. And we have already seen what is IBA rules to decide on the conflict of interest. There are color-coded soft rule, red, orange, yellow, and most of the jurisdictions arbitration law that includes this IBA. IBA means International Bar Association. Their soft law, they included in the respective laws. And another major kickstart point is preliminary meeting. Okay, now the arbitrator, he accepted the appointment. Now he will conduct the preliminary meeting. In the preliminary meeting, these are the agenda points. Arbitrator, he will declare what is his arbitrator fee, what are the cost, schedule of hearing, how many hearings will be there, when it will happen, the timetable, basically. And then the procedures, he will stipulate the procedures. If it is a technically complex, what are the experts required? Documents to be disclosed by the arbitrator, as well as if one of the party, if he seeks any documents from other side, that also they can list out. And they can decide whether they want to conduct online or one-to-one physical. Also, in my experience, document validation is an important process. Okay, especially in the construction contracts, it is all document oriented. But for the arbitration, when you go to arbitration, you must ensure that all the documents are controlled documents. Okay, otherwise, you will end up in losing the time and the cost, because arbitration is a very expensive process. Okay, so therefore, document validation is an important step in the commencement of the arbitration. You must ensure that all the documents are stamped and signed by the parties. Particularly, it should have been subjected to QA/QC audit. Okay, that is very important. And listing all the possible matters to be decided. So these are the things, agenda points for the preliminary meetings. I will show you one preliminary order from the actual scenario, from the real life arbitration. Madhu, hope it is visible.
Yes, sir.
Okay. So this is from a ongoing arbitration, the first preliminary orders. So it will stipulate about what are the parties and brief history, and then schedule of pleadings, like the timetable. It will stipulate the timetable, like what are the subsequent meetings and all. Okay. So he will also stipulate about the fee. What is his fee, expenses, how the parties they have to pay, his account details, everything, and then arbitrators details. Okay, all these things will be mentioned in the preliminary order. It is nothing but minutes of meeting of the very first meeting. That sets the tone of the meeting. That sets the tone of the arbitration proceeding. Okay. And then document submission, that also will be stipulated. Statement of claim. This is the order of submission in any arbitration. First, it will be statement of claim by the party who is invoking the arbitration. Then the other side will submit the statement of defense. He will say whatever he submitted is incorrect. Or he will add his own claim, that is called a counter claim. And to the counter claim, the first party, he will file his reply, that is called a rejoinder. Okay. And then arbitrator, he will frame the issues. Issues means the questions to be answered. Okay. And then parties will be asked to submit the evidences. So based on the issues and submitted evidences, the arbitrator will make the final award. So this is the whole process of arbitration. Okay, and then timeline. When the arbitration is commenced, the timeline also, it is very important, and the arbitrator is supposed to monitor the timeline. Okay, so this is about the commencement of arbitration. So now the stage is set for the arbitration. Okay, so in the subsequent sessions, you will see in detail about each and everything. Okay, so that is all for today.